Hello again. Welcome to Oilfield Strong webinar. As you know that we provide this on YouTube. If you just pull up Oilfield Strong, we're also doing it under podcasts through Buzzsprout to all of your podcast media. My name is Grant Swartzwelder. I'm president of OTA Environmental Solutions and one of the sponsors of this webinar series. We are, I think, very lucky to have an expert in his field and something that is starting to become more and more important in the oil field, and that's bankruptcy of service companies. And you go, what? But what we've seen is with all the consolidation and the some companies being focused only on certain companies, higher interest rates, there's a bunch of reasons that we'll get into. We're seeing a lot of oilfield service companies starting to have a lot of financial problems and resorting to bankruptcy. Well, today we have John Mitchell, who's a partner at the Katten law firm. He's been practicing bankruptcy attorney in Texas for 28 years, so quite a while, knows a bunch about this, and I think will be a great resource in anticipation for a situation you might find yourself in, or either as a customer or as a service company that might have an issue, or even as a competitor wanting to take advantage of a potential issue in the marketplace. So with that, John, welcome. And give us a sense, is that what you're seeing too, that the service companies are really starting to have some challenges, even with oil prices being pretty decent?
Yeah, I think so. And thanks, Grant. I appreciate it. And good day, everybody. And looking forward to spending a little time with everyone. Let me just start by saying, we're just going to be talking about really just a general overview of the law, and every situation is different. So please don't take this as legal advice specific to you, just some best practices. Always make sure and go consult with your own legal counsel about your specific situation. But glad to give everybody some thoughts, do's and don'ts, and best practices here as we go along. But to answer your question, Grant, yeah, we are. We're seeing a little bit of an uptick in some energy filings, and it's predominantly in the service company space. A couple of names that have filed within the last month or so: Oryx Oilfield Services, Tubular Synergy, Pegaso Energy, Land and Sea Industries, and some others. Reorg Research put out a little report and basically discussing how energy companies' filings are on the rise. And when looking at companies with more than 10 million in liabilities, 5 energy companies filed Chapter 11 during the month of July. And that's the most in a single month since October of 2020, when we had a rash of energy filings, as most folks know. And that represents actually 20% of all large bankruptcy filings during the month of July. Wow. And that's more than any other sector other than commercial real estate. So we're not anywhere close to where we were in 2020, where we had more than 85 filings in a single year. But I don't know if it's a trend yet, but it does appear that there's been an uptick over the last month or two.
And it seems like some of these companies filing, I can almost see drillers or completion companies because the number of wells might be shrinking. But you mentioned a tubular company, there's some other downhole. It's a whole variety in the service sector. So it's, and do you think it's because of that consolidation? I think interest rates clearly have gone up, so that's putting stress on. There's a lot of drivers for this, it seems like.
I think so, and I also don't know how much infrastructure is being built out. Some of this might also be impacting the midstream space. There may be a little bit more difficulty in building out additional infrastructure, and things are a little bit flat right now. Even though you do have not high, but you do have strong crude prices. You do have a little bit of a split with natural gas, I believe, with prices stay low, and so maybe a combination of several different factors. Yeah, I'm sorry. Go ahead.
No, you're exactly right. Gas price being low, that's affecting. And so we might see this with actual E&P companies if gas prices stay low. But right now, it's really just a service. So it's.
Yeah. Well, and I've got in that regard, too, I've got my eye on the Marcellus and the Utica, too. Very gas heavy. And we'll see if there may be a little bit more distress in that area as well.
Very good. Well, and as we said in the intro, we can look at this from several different perspectives, kind of. And so the first one is just really talking about if I'm an oil company and my service company that I've used for pipe or completion services, whatever, they file bankruptcy. I might know beforehand, but I'm probably just get a letter all of a sudden or a call all of a sudden. What do I need to think about? What are the issues there? Because I've got this relationship, I've paid them some money, they've done some work, but now they're in bankruptcy.
Yeah. So several different things to consider, and we can go through all that. The first thing is to find out immediately what type of bankruptcy they filed. So filing bankruptcy isn't uniform. There's several different types. The two primary that you've probably heard of are Chapter 7 and Chapter 11. Chapter 7 is a liquidation. And 99% of the time, when a Chapter 7 is filed, the company is shut down right away. The employees are fired, and the keys are handed over to a trustee. I like to equate it to somebody has passed away and there's a probate proceeding, and the trustee is the executor of the estate. And the duties of the trustee are to liquidate assets, collect money, and make a payment to creditors. So Chapter 11 is a little different. Chapter 11 is can be a reorganization where the company continues to operate, and so of course you have two very different scenarios. So the first thing you should do is determine whether you're in a 7, as we call it, or if you're in a Chapter 11.
And how do they know that? Will they get a letter, or will it just kind of, they call them up and it's like, oops, you're out of business? What's the communication of that?
So the official communication is a notice of the filing. So sticking with Chapter 7, if there's a Chapter 7 filing, then usually within 2 days, the company that filed the Chapter 7 must put a creditors list on file, and then the court will send out a notice pretty quickly, within a week, of the Chapter 7 filing. So the official notice will come, and it will say that the company filed and where it filed bankruptcy and who the trustee is and should you file a claim. And we'll get into the meeting of creditors in a minute and when the meeting of creditors is. And that will come in the mail. But remember, if this was one of your service companies, I think you'll find out practically pretty quick because the employees will probably walk off the job because they're not going to get paid, and the service just won't be provided. Nobody picks up the phone and calls you by law, but you may find out pretty quick when your contractor is no longer there.
So if you call up, they're in Chapter 7, they're shutting down. So we're just, they're obviously not providing any more service. What do I need to do to make sure that, I've paid them some money for some work. They might have done it. Maybe they're going to, what do I need to worry from a financial side? Obviously, from an operational side, it's too late. I've got to go find someone else. But from a financial, administrative side, what do I need to do to protect myself as an oil company?
Yeah. So in Chapter 7 and in most bankruptcies, when you're on the creditor side, or basically it's your service company, you've got somebody under a contract, they're working on a job for you, something along these lines, then financial and risk mitigation is key. And what you need to be very cautious about is not essentially paying twice. So you may be under a contract, you may have an obligation to pay. There may have also been some level of job completion that triggered a progress payment under your agreement. You're holding retainage and things of this nature as work is performed, depending on the nature of the agreement. Well, once the case files and the company is no longer in business, you are going to have to mitigate, Grant. You are going to have to go out and find a replacement service provider to finish the work. That may have to be done on a much tighter timetable. It may cost you more, and there may be additional costs. You have a right, something called a right of set-off in bankruptcy. So you have the right to set off your obligations under that contract, whether they arose or not, together with any future obligations or any retainage you may be holding, something along these lines, against the costs that you will incur in order to replace the services. So don't write a check to the estate right away. You may get a demand letter from the trustee, and you can talk about that with your lawyer at some point, but you have a right to net back against whatever balances are owed your cost of cover. And so that's most important, is you want to make sure you don't pay twice or overpay, and that you fully offset any damages you have against any obligations you have to the Chapter 7 estate.
Okay. So it sounds like you need to document kind of what you've paid, what you owe them, but then what these offsets are, and then kind of wait for it to come to you. maybe hire an attorney depending on the amount of money we're talking about?
Right. You may need to hire an attorney, you may not. Of course, that's always the safest bet to make sure that you don't trip into something. But yeah, I think you certainly need to protect your business, right? And you need to go ahead and make sure you go out and find somebody else to continue working. And most trustees are not going to mind that you do that because the trustee isn't going to be running the business. But if you don't want to hire an attorney, there's nothing wrong with picking up the phone and calling the trustee. The trustee may have counsel, and that would be on the notice, and basically say, look, here's the situation I'm in. You're not operating the business. It's a Chapter 7. I'm going to go out and I'm going to hire somebody else to finish the job, and I will offset against what I owe you if I owe you anything. We can take that up later and see what they say. If there's some resistance there, then you may need to hire counsel to help you out. But otherwise, they may say, go ahead, and then we can worry about this later, and we'll figure out if there is a net obligation back to me. But you could open the dialogue with the trustee about that.
Okay. So that's Chapter 7. Chapter 11 seems a little trickier because from that, I think they're still operating. And so you're kind of, I don't know, in a limbo, but you're kind of in an awkward spot, it sure seems like. How do I play that out as an oil company with a service company in Chapter 11?
So it gets a little bit more difficult, you're right. And you don't want to do something which would expose your company to liability if a Chapter 11 is filed. Most of the time, at Chapter 11, the company will remain operating and is looking for an opportunity to reorganize. It wants to restructure its debts and obligations and reorganize. And most likely, you're going to be party to something that we call in bankruptcy an executory contract. You still have an obligation to pay for services provided. The debtor still has an obligation to provide the services. So when the company files Chapter 11, then the debtor most likely won't want you terminating the contract because the debtor may want to continue to perform under the contract so that they can continue to operate their company and restructure. So you can't immediately go out and hire a replacement. You can't terminate the contract right away. That's prevented by statute and by federal injunction. And instead, you must perform your obligations under the contract, and the debtor must perform its obligations under the contract. You may have some remedies which we can get into if you'd like, but yeah, you must.
I was about to say, no flexibility on that. You're stuck with that service company, even though they filed Chapter 11.
To an extent. You're entitled to something generally called adequate protection. So the debtor is given the right to look at its contracts. Contracts are both assets and liabilities. The debtor has the right, in looking at a restructuring plan, to decide which contracts it wants to keep and which contracts it wants to get rid of. It's called assumption or rejection, but think keep a contract or reject a contract and terminate it. And the debtor gets to do that. And if the debtor wants to keep your contract, then it's hard for you to get out of that contract. What you're entitled generally is to something called adequate protection and adequate assurance of future performance, meaning if the debtor wants to keep your contract, it's got to be able to establish, if you bring this issue to the court, that it can continue to provide the services under the contract and can continue to perform. It's got the financial wherewithal to do it. It's got the employees to do it. It has the technical capability to do it, and it can do it into the future. If you believe that the debtor can't do that, then it's up to the court to allow you to terminate the contract or force the debtor to reject the contract, as we call it, to let you out. So let me give you an example. You go in, you basically say, I understand because of the filing, employees have left. They don't have this critical engineer, whoever it may be. They cannot perform, Your Honor, and I'm entitled to adequate protection, meaning they've got to go out and replace these critical employees to do this job. Or alternatively, I'm looking at the budget they filed with the court, and I don't think they have the financial ability to continue, and I don't want to look up 2 months from now and have the company cease business. And so I'm entitled to perhaps you can hold off on some of your retention payments being paid, or alternatively, Your Honor, Judge, perhaps they need to give me a budgeted line item to make sure that their employees are being paid or that they can cover their costs. You're entitled to adequate protection and adequate assurance of future performance that they're going to be able to perform. There's a lot of other factors that go into it, but generally that's it. And if you're concerned about that, then you can ask the court for relief in order to get out and allow you to terminate the contract and go hire a replacement service company for you. But that will be up to the court. So Chapter 7, company shuts down. You can almost always do it immediately. Chapter 11, well, we have to see how the debtor's doing, and you have to go ask for permission from the court. Otherwise, the debtor will be able to continue to perform.
Okay. Now, and you talked about retainage, you talked about payments. So let's talk a little more about that. If I've paid for work done or I paid a deposit, I've made payments to them, then what do I need to worry about to make sure that that money, I don't lose it or I don't have to pay more? How do I handle all these payments?
So let's start with payments that you've already made. If you've already made payments to the debtor, most likely those have been commingled in a general operating fund, I'm just presuming.
Yeah.
And the debtor has it, spent it on payroll, spent it on debt service, whatever it may have been. And that makes you a creditor and of the company. Now, if you have your contract in place and you've made payments and the debtor can't perform and ultimately the contract is what we call rejected but terminated, then you become a creditor of the debtor and you receive a damages claim for the amount of damages, the work that wasn't performed, what you already paid, as well as your cost of cover to go out and hire a new contractor to complete the job. And you can set off against any future obligations you have those damages claims. And presumably if you're making regular payments, progress payments, and you have some retainage, presumably you won't have an affirmative obligation to write a check back to the estate. Most likely you're going to have a claim against the estate. There could be some situations where you're very close to completion of the job, whatever that may be. You've got a 10% retainage. It didn't take much, if anything at all, to finish it with a third party. You may end up with retainage left over and above what your cost of cover was, and you would have to write a check back to the estate and pay that. You would. But that's really the situation if you've made payments. If you are obligated to make payments, that's a situation where you may want to decide, do I think this debtor can perform, and do I need to go get court relief and some protections before I make write another check that I may not ultimately see the benefit of. If you have made payments to a debtor and it files Chapter 7 or it rejects your contract and you do have a large damages claim because you had to go out and it was a high cost of cover and you have a large claim, that makes you an unsecured creditor. And there are certain things you can do in the case if you want me to get into that, Grant, as a creditor.
Yeah, no, I think that's helpful because I think most of these vendor type relationships will be unsecured. And
Right.
and unfortunately, that means you're down the pecking order, and you better know what's going on because you stand a chance of, generally speaking, on the bad end of the deal, depending on what the
Right.
asset and all that. So yeah, I think that's worth talking about.
Yeah, and so if in most situations your claim will be an unsecured claim. The unsecured claim is almost always the lowest priority of claims. It's not a secured claim. It's not like a tax claim, which gets a higher priority, or the cost of administering the estate receives a higher priority. You're a general unsecured creditor. It's the lowest in the priorities. It doesn't mean you're only going to get pennies on the dollar because every case is different, but maybe you're only going to get pennies on the dollar on your claim. But a couple of things to think about when you have an unsecured claim. You may have a very large claim, $3 million claim. But as we like to say in the industry, that may just be monopoly money because you have to look at what the return is going to be on that claim. And it may only be, like I said, 5, 10 cents on the dollar, if that. So be careful about spending a lot of time and effort and legal fees chasing something on behalf of what appears to be a large claim on its face, but in reality is only going to be a few cents.
So how do you figure that out? Are there filings that show their balance sheet to see what the assets and the claims are, and you can do your own math, or otherwise, how do you know?
Yeah, so there's a couple different ways to do that. So every debtor must file a schedule of assets and a statement of financial affairs within 14 days of the filing of the case. It is a lengthy schedule of all assets and liabilities that the debtor has, and then it is almost like a mini audit, the statement of financial affairs, about roughly the past 3 years of the debtor's business, its revenues, and a lot of questions about transfers that may have been made, things of this nature. You can look at that, as well as if the debtor is operating, you can look at monthly operating reports that the debtor files. You may look at some other filings that they make in the case. You can use financial advisors or lawyers that work in this space to help you out with it, or you might be able to do it on your own. But you might be able to take a look and see that, look, okay, this debtor, if its plan is to restructure, if its plan is to sell all of its assets, or if it's a Chapter 7 that's liquidating, if there's a bank with a lien on all the assets and it's a $20 million lien and the assets, if you're looking at it, are worth $5 million, the secured creditor is going to take everything. There's going to be very little. Other times there may be litigation claims. There may not be large secured claims. There may be assets with value. Or there may have been lien issues where a bank isn't going to be able to enforce its lien against the assets. Then there might be a sizable return to unsecured. Again, every case is different, but you might be able to take a look at it and come up with a little bit of an analysis how much time and effort to put in. Be careful. Deadlines run fast in bankruptcy. If you want to participate in the case for recovery, you need to put a proof of claim on file. Proof of claim is a very simple form to fill out. They're designed not for you to need legal help, but you always can consult a lawyer if you need to. But if you miss the claim bar date, it could be difficult for you to participate in any return if there is a return. And there's a lot of tight deadlines. Something else you can do to participate in the case, it's important if you want to stay active. There's something called a 341 meeting, or a meeting of creditors. That will be on the notice we talked about, Grant, when the meeting of creditors will be. You don't need counsel. It's usually telephonic these days, or via Zoom. And it's where the debtor will come to a meeting with the United States trustee, who is a person that oversees cases, along with a principal of the debtor, the CEO, chief operating officer, chief financial officer, and answer questions about the company. All the creditors can dial in and listen. What the company is, how we got here, and if it's a reorganization, how we plan to get out, and what our intent is. And then the debtor must make itself available for questions from creditors. So creditors on the phone can ask questions. You don't need a lawyer. It's not in court. And you can ask questions about your particular claim or follow-up questions about the assets or the restructuring. I would encourage creditors to telephonically go to the 341 meeting. And then lastly, if it's Chapter 11, you might get an opportunity to participate on something called a creditors committee. If you have a sizable claim and it's a sizable Chapter 11, the United States trustee might try to form a creditors committee. It's a committee of unsecured creditors, and you'll be asked to fill out an application, and they may or may not appoint you. You don't get paid, but this committee looks out for the interests of the unsecureds and can appear in cases and argue through counsel and financial advisors about the debtor's restructuring. You get to participate in the debtor's restructuring. The great thing about it is the committee can hire counsel and financial advisors, but the debtor must pay those costs. So it's an opportunity for you to participate in the case and to look out for the best interests of all the creditors and try to maximize the return. So if you get invited to sit on a committee, you should consider it.
But again, likely is that that's a larger bankruptcy. And what do you mean by larger? Like, is it typically 100 million of assets or liabilities, or is it, or, you know, if it's a small 5-10 million, probably not?
Well,
rules of thumb.
So if it's going to be under around 2.5 million, it will most likely be what we call a subchapter 5, which is a small bankruptcy, which there are no committees. Anything over that, the United States trustee, anything over 2.5 million in assets and debts, the United States that isn't sub 5, as we call it, the United States trustee is charged with trying to form a committee and must try to form a committee. The practical side of that is in the smaller cases, let's just say I'm going to just say 25 million and less, I'm just going to throw that number out there, there's no bright line test, is the creditor claims are going to be smaller and the debtor's cash flow is going to be smaller, and adding an extra advisor that the debtor has to pay for, financial advisor, may break the case. Or the creditor's claims may be small enough, and remember, that's just the claim. The return may even be smaller. It's not worth their time and effort sitting on a committee. They don't get paid for it. So the trustee may try to form a committee, but it probably won't happen. The larger cases, especially when you get up 50 million assets and debts, often you'll see a creditor committee form. And if you do get invited to a case like that, you should consider it. And what the United States trustee tries to do is get a good cross section of the type of creditors that are out there in order to sit on committee. Let's just say you have somebody that holds an unsecured line of credit, and you have somebody else that maybe has a contract, with a service provider, and somebody else maybe, sometimes employees that are former employees of large claims. They try to get a good cross section of the types of creditors on the committee as well, so that all the interests are represented.
Okay. Very helpful. Yeah. Now, let's shift a little bit. A lot of this information I think would be applicable to if I'm a service company and I'm starting to have financial problems. Let's walk through. Okay, I'm starting to feel the pain. It's out there. I'm not sure if I need to file or not. How do I think through that? What do I need to start doing in preparation for filing bankruptcy?
So the earlier the better. I'm sorry, go ahead.
As a service company, as
Right.
the company filing, it could be an oil and gas company, but kind of the company actually filing from that perspective, John.
So this is really just general advice to any distressed company. The earlier you get your professionals involved, the better. I can't tell you the number of times that I've received a call and it's, hey, John, we've got a problem. Okay, and I'm bouncing payroll next Tuesday. Oh, I need to file Chapter 11. Okay, that's great, and I'm glad you called me. But simply by filing Chapter 11 between now and next Tuesday, you're still going to bounce payroll on Tuesday. There's no slush fund that's created. Suddenly there's liquidity available to you.
Right.
But had you called me 3 months ago, if you're seeing 3, 4, 5, 6 months out, I'm going to start to have liquidity issues and cash issues, and I may go negative on my cash or whatever it may be. Get the advisors involved right now. You may not need legal advice. It may be more financial advice, or it might be legal advice. But pick up the phone and call an advisor that is experienced in the restructuring field, because the sooner we can start planning, the better. Let me give you a couple of examples. Number one is there are many lenders, special asset funds, special debt funds that loan into a restructuring scenario. And so you may not have had access to additional credit, but financial advisors and others have a lot of relationships that may be able to bring specialized lenders in to help your situation. Or alternatively, some lenders don't want to loan into a distressed situation pre-bankruptcy, but once a company files bankruptcy, it's allowed to borrow money, and they're called DIP loans, debtor in possession loans. And the court can give a lot of special protections to a DIP lender. Liens on assets, second liens on assets, advance payments, priority claims, a lot of control over the debtor without risking being, lender liability and those types of claims. And so a lot of lenders are much more comfortable loaning in. And that capital may have been available to the struggling company, but it takes time to get it lined up, ready to go. You put the company in, and then there's the capital, and you can make your payroll. Say, John, I'm filing, I've got to file between now and Tuesday. I don't have time to line that up, or your financial advisor doesn't have time to line that up. We may also advise getting in earlier. The thing about bankruptcy is most debts, not all, but most debts stop when you file, and there's no obligation to pay them on a go-forward basis. You have to be able to operate in the black.
Is that vendor debt? Is that bank debt? Any debt?
Vendor debt, bank debt, any debt. There's that you cannot pay pre-petition, as we call it, pre-bankruptcy debt without court permission. And now, you probably want to go ahead and pay your employees and get court permission. You don't want them walking off the job. You probably want to pay critical vendors that you can't replace. So there's some things you can do, but my point is that you start from the proposition that none of your debts have to be paid. But if you continue to operate and you continue to generate revenue, well, that's going to free up additional revenue that you can then maybe service your payroll and service your critical vendors and continue to operate while you work on restructuring your debts and obligations and restructuring your company. You just don't have time to do that if you're going to bounce payroll next week, and you don't have time to build cash. So it might be better to go ahead and file a little earlier when you have a little cash in the bank, and then be prepared for your liquidity issues that may be arising in a month or 2 or 3. Another thing too, Grant, is you may not need to file Chapter 11. Chapter 11 is expensive. A lot of lawyers are involved, a lot of advisors are involved. A lot of times, and not for today's call, but vendors put companies on a cash basis only, or they expect cash on delivery, COD, things of this nature, and it can be an expensive process. Every situation is different. Creditors know this, and that it's become an expensive process. And if it's not a holistic issue with the company, but one or 2 points of pain, you might be able to negotiate a resolution to that outside of Chapter 11. Chapter 11 lawyers and advisors come to the table, but then immediately enter into dialogue with some of your creditors or other members of your capital structure, and you can maybe avoid it altogether if you have more time.
And I would think that the driving would be your senior bank debt, maybe one supplier that you're really beholden to, but those people are willing to work with you, you think, outside of bankruptcy?
They very well might. Yes, they very well might, because they may want to see you succeed. A supplier may want to see the company survive, and so they continue to have a customer. The bank, look, sometimes an operating company and an opportunity to continue to service the debt may be more beneficial than a liquidation. Liquidation can not always, but can distress prices, and their recovery may be better for them if the company continues to operate, and they may work with you. Again, every situation is different, but you lose that opportunity if you wait too late.
I know when I have customers that are slow in paying, if they just communicate with us, I'm a lot more flexible. Can you do that, or are you creating potential liability by sharing certain things or talking to them about your financial situation or anything? Or you kind of have to talk to them to tell them what's up, but then you run the risk that I guess they could push you into bankruptcy, or it seems very kind of unclear.
It is. I would say most sophisticated lenders understand when the company comes to them with a problem and says, hey, look, we collectively have a problem, and we need to work this out. And I'd say most sophisticated lenders say, we understand, let's sit down, let's talk about it, let's go through your finances, let's go through your cash projections, and most of them want to work with you. That is true. That is a risk, Grant. Some vendors may say, that's it, I was burned in another bankruptcy 5 years ago. I always swore to myself I'd never be burned again, and they cut you off or they put you on COD, and that's that. It depends. That is true. So I do think you need to be strategic about which ones you approach and how you approach them. Sure.
So if I'm having these problems, is there a certain point that I decide I need to just file Chapter 7 over Chapter 11? I know Chapter 11, we all think we can always survive, but at some point you just need to call a calf rope and file Chapter 7.
Yeah.
Where's that point, or how do I think that through?
So a couple different thoughts on that. Number one is, if to file Chapter 11, you have to pay your debts, as we talked about the fact that you don't have to pay your pre-petition debts, but you have to be able to operate in the black from and after the day you file Chapter 11. So, for example, and the theory is this, and it makes sense if you think about it. The theory is, look, if the company cannot operate in the black just on a daily basis, then what's the point of what is there to do? Exactly. There's some situations where you may let the company and say secured creditors may want the company to operate for a short period of time while it sells assets in Chapter 11. But essentially, the idea is if it can't operate in the black, then it really is just liquidation. And so if you come to that conclusion, and if there really isn't a need to operate the company while you sell it as a going concern, and you just want to liquidate the company, Chapter 7 may be the right option. And put the company into Chapter 7, and then let a trustee liquidate the assets and write checks to creditors. It provides some finality for your creditors too. If a company just goes away and you just quit operating, you shut the doors and you just go away,
right.
Creditors are, what happened and where am I going? Do I need to file a lawsuit? Do I need to collect or whatever? The thing about a Chapter 7 is it provides finality. People understand it. They know it. They put a claim on file, and if they get a check in a couple of years, it's found money. So it does provide some finality for your constituents.
Okay. The last piece of this is, as a competitor, if I see a company filing or thinking about filing or kind of teetering, or they've filed 11 or 7, in a lot of ways I see that as an opportunity to either get a customer or maybe pick up some equipment, get some employees. Is it all positive for me as a competitor?
There's some positive, but there's some risk. So let me start with the risks.
Always good.
And yeah, so the risk is, remember, the company that files Chapter 11 is trying to reorganize. The court and the creditors of that company are going to want it to usually reorganize, keep jobs, keep employees, and let the company live to fight another day and operate. So if you see the company struggling and it is either going to file Chapter 11 or in Chapter 11, be careful. You run the risk of, let's just say, a tortious interference with contract. Remember, those contracts are still alive as executory contracts, as we discussed. And if you're in talking to counterparties of the contract saying, I can do a better job, this company's going to go out of business, they're going to leave you high and dry, you don't want to be stuck with a tortious interference claim. And by the way, that bankruptcy court is going to get to that claim much quicker than, say, somebody that tries to pursue that outside. So be careful. And of course, be very careful interfering with their employee base. That won't be looked upon kindly either by the court. If you're not sure if the company has filed, something else to be careful about is who you talk to about this competitor or this company that you've got your eye on. If you basically state that someone is bankrupt or insolvent and they're not bankrupt or insolvent, that can be libel or slander. So it is slanderous to say this person is bankrupt and they're not. And so be careful about that, because you don't want a libel or slander claim coming back against you if suddenly it gets out there. So outside your organization, be careful who you discuss, who might be having trouble with respect to your competitors. Those are some of the risks to look out for. But there's some benefits. Keep your eye on the case. There may be an opportunity for you to acquire assets or market share, whatever it may be, from the struggling competitor. Anytime a debtor is in Chapter 11, it must try to reorganize for the benefit of the creditors. It must entertain offers to purchase assets. And there may be some values there. The company may be bleeding cash. It may need to create some liquidity. It may need to move some non-core assets to its operations. And it may be under pressure from a secured lender to do it, to pay down the debt. You may be able to get in there with an offer to buy some assets at a value. And then on top of that, there's a lot of protections when you buy assets from a debtor. You get a federal court order that says you own it free and clear, no liens, no claims, no encumbrances, nobody can come after you for a fraudulent transfer, alter ego, nothing like that. And you get a federal court order that's very, very strong, and there's a lot of protections for you. So, as we like to say, if there's a little hair on the asset, buying an asset from a Chapter 11 debtor may be a good value, and that federal court order can protect you as well.
John, this has been fantastic. Clearly, with the interest rates, all the dynamics in the industry, I think this is hopefully not the beginning, and it doesn't continue, but unfortunately, it probably will to a point. And your knowledge in the industry, I think, is very, very appropriate there. If people want to visit with you about anything, how do they reach you?
So, sure. So my phone number is 469-627-7017. That's my office line. Feel free to give me a call. My email is john.mitchell@katten, katten.com. Or you can go to www.katten.com, and that's our website. And we'd be glad to speak with anybody about any further questions they may have.
And you're in Dallas. You go to Houston a bunch, so your oil.
Yeah.
You do a lot in the oil, and I know from a person that has used you, you've got a good business sense. So I highly recommend you, John. So good. Well, hopefully this has been helpful. John, thank you very much for your time. And
absolutely.
We'll talk soon.
Great.
Thanks, everyone.
Have a great day. Thank you. All right. Bye-bye.